folks. I guess this is good afternoon, actually, isn't it? Yay, good afternoon, everybody. This is Randy Brunson with Centurion Advisory Group here for this episode of the Stewarding Family Wealth podcast, brought to you by Centurion Advisory Group. You can learn more about Centurion at centurionag.com. Short version, we're an independent wealth management firm. We serve individuals and company owners who've done well in business and in life in a variety of ways, but purpose here today is not to talk about our firm. The purpose here today is to have a phenomenal conversation with our good friend, Mr. Cleve Hill. Cleve, welcome to the studio.
Glad to be with you, Randy.
Good. Well, I'm glad you're here as well. And you're an attorney.
I am.
You are with the firm of Hill and
Watchko.
Hill right. And Watchko. All right. So we were visiting just before we started the podcast. We're going to do a couple of episodes this afternoon. Mm-hmm. And what I found is I like stories. You like stories. Mm-hmm. Mike, our engineer behind the desk there, he likes stories. So let's just talk about you. And you mentioned just before we went on the air, something I didn't know. We just hadn't talked about this, but you are a sixth generation Georgian, but specifically from your people are from Cherokee County.
From Cherokee County, both sides of my dad's family, his mother and his father, their people moved to Cherokee County back before Cherokee was an incorporated county. So Prior to the 1830s, I believe Cherokee County was chartered by the state in 1831. My grandmother was a Reinhardt. Her ancestors started Reinhardt College, now Reinhardt University in Waleska. So we've been around a little while over there. So I'm sixth generation. My kids are seventh because we still live there. Okay. And so it's home, and we've seen a lot of changes there from extreme rural to part of the metropolitan Atlanta community now.
Just during your growing up years and through your adult life, your career, you've seen massive change in Cherokee County.
Massive. One litmus test for the line of work I'm in, being a wills, trusts, and estates attorney, one of the markers in the state law related to our probate courts is that a county that has a population below 90,000 people, it's not required to have a lawyer as a probate judge. So we have 159 counties in Georgia. A vast majority of those are small counties, and so you will run into what we call lay judges in a host of counties across Georgia. That's starting to change quite a bit, but Cherokee County now is over 90,000. We have been for probably about a decade and a half now, and we've had lawyer judges. But that's just one of the markers that I look at as counties are growing. Has their probate court gone to a lawyer judge? Okay,
so that's interesting. I like that kind of interesting trivia. So Georgia law is that if a county has fewer than 90,000 people, they do not have to have an attorney as probate judge. They can have a layperson, an experienced layperson to serve in that role.
That's right. And so what happens in those counties is if there is a dispute in a probate matter and we have a non-attorney judge, then the losing party has an automatic right to have the entire case from soup to nuts reheard in the Superior Court. So those counties, if a litigant does not like the decision, they don't appeal to the Georgia Court of Appeals or the Georgia Supreme Court. They first have to go and retry their case in Superior Court. Then the losing party, if they want to appeal, that's when they get the entree into the appellate courts of Georgia.
Fascinating. Speaking of, I want to come back to your specialty in a minute.
Sure.
We've got so many things I'd love to cover and hear more about you and so on and so forth. But Georgia has 159 counties, and I believe memory tells me that Texas, which is significantly larger in terms of just the real estate, has 77 counties. I believe that's correct. My friend Bill, who's been gone for a couple of years now, he was a retired attorney and a fan of history as well, and he could give you the family history of every person that Georgia counties are named after, like Cherokee County or Bullock County or so on and so forth. Bill told me one time, fill in the details here, but as I understand it, the reason Georgia has 159 counties is that when the county system was created, the lawmakers at the time wanted to make sure that every taxpayer, every citizen in the state was able to get to the county courthouse within a day's ride on what at the time was a mule or donkey or horse. Is that the deal?
I have heard that, and you'll hear the Superior Court judges, especially the older and retired ones, they talk about riding the circuit.
Okay.
And so, for example, 30, 40 plus years ago, Cherokee County and Forsyth County and Gilmer and Pickens, I think, were all in a single judicial circuit. So the Superior Court judges now, which typically just sit in a given county because we've grown so much, those judges used to ride the circuit. They would go around to the various courthouses. About a third cousin of mine, Marion Pope, who is now in his late 90s, a lawyer, served on the Georgia Court of Appeals for 25 plus years. I have had the opportunity to talk to Marion several times over the years about his career, and one of the phrases you will hear repeatedly in talking with him is how much he loved riding the circuit back in the days. He went on the Georgia Court of Appeals in 1981, I believe it was, and so prior to that he served Cherokee, Forsyth, Gilmer and Pickens, I believe, was that single circuit.
That's interesting. This is totally off the subject, but you were talking about riding the circuit, and it brought to mind there's a publication in Georgia. This may matter to Georgia listeners or not, but there's a publication in Georgia called Georgia Backroads. Okay, and I believe it's a quarterly publication. I subscribe to it. It's a softback periodical that's focused purely on the history of Georgia, and it's a fascinating publication.
I need to get subscribed to it then.
Georgia Backroads, and they have a website. You can Google Georgia, look up Georgia Backroads, and subscribe to it. But it's a fascinating look. But one of the regular features in that is called Rural Historic Churches of Georgia. Okay, and one of the founders of Georgia Backroads, just obviously a history fan, right? A history buff, and has taken time and interest to do this. But they have published a coffee table sized book on the rural historic churches of Georgia.
I'm sure.
And I gave one to our mutual friend Charlie here for Christmas last year, and it's a fascinating look. But what brought to mind when you were talking about riding the circuit is I grew up in the Southern Plains in Oklahoma. But if you travel Georgia and across and go west, many small towns or places that used to be small towns, they have these very recognizable rectangular clapboard white churches. The small Methodist churches, that just populate rural America, and especially across the South and the Southern Plains and so on and so forth. I don't have any relatives that did this, but know the stories of the preachers that used to ride those circuits. Indeed. Where they would, once a month, once every 5 weeks, they'd have a live pastor, and the rest of the time they just met outside of that. So when you said riding the circuit, I thought that has several applications.
Yeah, I think you're right.
Anyway, check out Georgia Backroads, and if you like coffee table books and Georgia history, there's also that coffee table book called Historic Rural Churches of Georgia, I think.
I'll check it out.
But yeah, check that out. Let's talk about the law. So the laws cover so many bases, but you and your team at Hill and Watchko, you specialize in estate planning work and corporate work.
That's right. So our practice is primarily wills, trusts, and estates. Elder law, under the topic of elder law, traditional estate planning, but also long-term care, Medicaid benefits. My partner, Sarah Watchko, is a nationally certified elder law attorney, one of only, I think, 13 or 14 in the state of Georgia. So under elder law, there's traditional estate planning, Medicaid planning, veterans benefits, and then special needs planning for families with disabled children and adults that we need to do planning for. We do a little bit of fiduciary litigation when executors, trustees, agents under powers of attorney have been accused of misconduct. We'll get involved in those disputes sometimes as well. And then because so many of our clients are small business owners, we do a little bit of corporate work as well. There's oftentimes succession planning for the businesses that dovetails into the estate plan as well. But that's the kind of the universe of what we've chosen to focus on. In Georgia, an attorney really is prohibited by the state bar rules from holding themselves out as a specialist in a particular area. They've made a couple of exceptions, elder law being one of those, where they've recognized the national test that lawyers can take to be certified as an elder lawyer.
Good. Oh, by the way, speaking of counties, our ever-present engineer back here, Mike, has clued me in because thank you for bailing me out here because I was certain that I was getting an email, a text, a phone call from somebody saying, boy, you don't know what you're talking about. And it's true. I did not. So I'm not sure which. Maybe it's Oklahoma has 77 counties. I should know that. I survived Oklahoma's civics class back in whatever 8th or 9th grade when they do that. Texas, here we go. Texas has 254 counties. Okay.
Yeah, I thought Georgia was second only to Texas in the number of counties.
That's exactly what Mike found. See, learn new stuff every day. So thanks for bailing us out, and thanks for the new information. So for those of you trivia buffs that are listening, Texas has the most counties at 254, Georgia second at 159. Now, here's what I'm going to have to look up later today is land size. Okay, because Texas is, third largest after California and Alaska, I believe, in land size.
That sounds right.
That's what I'm trying to remember from U.S. history. I think that's right. And Georgia's smaller. So that's your area of focus is wills, trusts, and estates. I know that you and I met originally through your senior business partner, Phil Bettis, who was actively practicing at the time, has since retired, and of course my friend and business partner Charlie. Those two guys go back in Cherokee County some decades. And you joined Phil, and I'd met Charlie along the way, and so you and I ended up meeting. But you did say that you do some corporate work since you represent so many business owners, and of course we work with business owners as well, which is one of the ways you and I have had the opportunity to work together over the last few years. For those of you that own businesses that are listening, if you have business partners or if there's more than one shareholder, I guess, or if it's an LLC, more than one member, okay, and I'm going to depend heavily on you, Cleve, to keep my language and terminology clean and straight, right?
Will do.
Thank you so much. But if there's more than one member, more than one shareholder, then I believe it's absolutely critical to have a well-built operating agreement. And I will tell you what we experienced. Back in 2006, our firm, Centurion Advisor Group, went from one shareholder, which was me, to four shareholders. There were just some people that I'd identified that wanted to be a part of what we were doing and wanted to invest in the future of the company and so on and so forth. And I'm still not completely clear on the why behind that, except that that's what happened, right? We needed a well-built operating agreement, and you helped us with that. You helped us put it together, and I want to ask you about what some of the features or clauses that a well-built operating agreement needs. But as far as I'm concerned, the test of an operating agreement is how well it works when there's a trigger event that commands performance. Is that a good phrase?
That's totally fair, and you can draft those things and try to, as my mentor you've mentioned, Phil, always likes to say, peeling the onion. There's always one more layer underneath, and so the attorney's job when they are working on those agreements, or really anything, is to try to anticipate where those trigger points are and how that process and procedure is going to work when those triggering events happen. Whether that's the disability of a shareholder that works in the business, are we going to continue paying them, and is there a period of time after which they would be bought out if they were actively working in the business but no longer can? Does that trigger that buy and sell at that time? Of course, the one we all think about is, what if there's a death of a partner, a shareholder, a member in the organization? Is their spouse, is their beneficiary under their document going to get to step into their shoes? 9 times out of 10, people don't want to be partners with their partner's spouse or children or what have you, and so having that structure in place to say, if there's a death, here's how we're going to go about the purchase. You always want to look at how we're going to set the value of the business when the triggering event happens, and there's multiple ways to do that.
I'll mention ours, and I want to come back to you were talking about valuation. I want to cover what are some of the key clauses that need to be included, or some of the key themes that need to be addressed within that operating agreement, because we do have a number of business owners that listen to our podcast. So I will tell you our experience. You put the operating agreement together. It's 2006. At the time, we had 4 shareholders, 3 of whom were married. And the decision that we made, which I thought was an outstanding decision, was not only did all the shareholders sign the agreement, but the 3 that were married, their spouses signed the agreement. Okay, that was in, let's call it the fourth quarter of 2006. Thanksgiving of 2017, one of our shareholders died. In the shareholder agreement, there was a clause that addressed what happens if a shareholder dies. What are we going to do? Okay, and we were intentional that in the event of the death of a shareholder, the estate of the deceased must sell, and the company or remaining shareholders must buy the shares in question. And of course, then we also had a valuation formula that described what the value of those shares was. Okay, the agreement was so well written. I still have my original. I have it tucked away. I have my original. I know Charlie has his, but the widow, who was the executor of the estate, she found her copy. Bob was the deceased shareholder. Bob had held on to his. He filed his things well. He held on to his, and his wife found it. Okay, and she had it. And of course, she had her son had a friend who was an attorney, which is as it ought to be. All right, but it was a by-the-book transaction. She had the agreement. The agreement said, here's the way you value it. We valued it. We had our CPA run the numbers to calculate value as supporting documentation. I reached out to you. You prepared the documents to effect the transfer, the various and sundry documents that were needed. We came up to your office in early 2018, and we sat there. You had the sleeve of documents for signature. We brought a cashier's check for the amount. And it was literally just a by-the-book transaction, just about as clean as it could happen. And I credit that to the fact that, yes, Phil taught you well, but you were very attentive to, okay, what needs to happen here for our business, for Centurion Advisory Group? What needs to happen in the event of, what are the triggering events, and then what needs to happen? And it was as clean as it could be. And then the one way we have modified, and we made this modification, I think in 2015 before Bob passed, but the one way we have modified the agreement since its original drafting is we modified the ownership language to allow shares to be owned by a trust for purposes of estate planning.
And
okay.
that gets overlooked a lot in these documents.
Okay, so let's talk about because we're going to do a couple of episodes here, and I do want to shift our attention to things like succession planning and estate planning, and we may have to come back and do some more of this because there's so much to cover. Sure. But let's talk about the operating agreement for a minute. So in an operating agreement, which assumes that you have more than one shareholder or more than one member, what are some of the key clauses or themes that need to be addressed within that?
Sure. Electing your management structure, whether that's officers, whether that is under the LLC concept, you can call them managers or CEOs. You can use traditional corporate nomenclature for the offices in an LLC as well. So your management structure, talking about how the finances are going to be handled, who's the partner, who's the manager that's going to be in charge of all of the tax-related issues for the organization. Talking about death and disability, like we've been mentioning here. What are those triggering events, especially on the disability side? What is the period of time that the person would have to be away from the business and unable to perform before those events are triggered? Related to disability and to death, how are we going to fund the purchase? Are we going to go out and get life insurance or some sort of policy that would be, paying out upon a disability to give the liquidity either to the business or the various shareholders or partners to purchase from that person? So that kind of then goes hand in glove. What you mentioned earlier is the valuation. How are we going to do this? And we see those various ways. The most common, I would say, is getting an appraisal from a certified business appraiser to come in at that time and give us a figure. As you mentioned, or working with a CPA who can extrapolate the numbers and run the formula based on what's been put in the agreement. If there are multiple partners that perhaps this is the first time they've been through it and maybe they haven't built the level of trust with each other yet, they will do a combination of things. They will set a procedure where the estate and the business can both get an appraisal done of the business, and they'll average the two together, and that's going to be the purchase price. along those same lines, you want to set out and be real clear if we're going to allow the estate or the the disabled partner through their representative to be bought out over time. How are we going to set the interest rate? Over what period of years or months will the payout occur? And we even get so specific with some of them that we go ahead and draft a sample promissory note that's attached as an exhibit to the agreement, saying that if the purchaser in the transaction does elect to pay it out over a period of years, here's the promissory note that everybody has agreed to ahead of time. This is what it's going to look like.
This is the structure, so just use a template promissory note, make it Exhibit A, Exhibit B, whatever, and embed it in the sleeve of documents. A fixed interest rate, or is it more common? I'm just curious. Now, is it more common to tie it? I mean, like the prime rates, what's published in the Wall Street Journal, those kind of things. Is it common to tie it to prime rate as defined in, that kind of thing?
Prime is the most common that I run into when it is not a family business, where it's friends or business associates that have come together. They will do something like prime. When I'm dealing with intra-family transactions, then the very common way to do it, because the family doesn't want to take advantage of each other, is they'll tie that interest rate to the applicable federal rate that the IRS publishes on a monthly basis, which is usually much less than prime. And that is I still run into this quite a bit. Let's say there's a mom and pop who are running the business. Right. They're wanting to sell it to child, and it's not uncommon for me to hear, oh, we're not going to charge interest on this. Well, Uncle Sam requires that interest be charged, and even if you agreed not to do so, the IRS is going to impose that applicable federal rate on the transaction. So I typically tell everybody, well, I understand you want to, kind of give a break here, but Uncle Sam has told us we've got to set something, so let's use the lowest one that we can reasonably get away with.
And typically the applicable federal rate, or what's often referred to, or I see it as AFR.
AFR.
Right, that's AFR. It's used for a variety of purposes when it comes to trust in estates and estate planning. And,
correct.
And it changes monthly?
Monthly. They publish it monthly.
Right, because we get a push email from something we subscribe to that gives us the AFR. Mm-hmm. So, but that is for most purposes, that's about the lowest available interest rate, right?
It is.
Yeah,
it is.
Because that's what I was thinking.
That's going to be the one that the IRS will just default to if you've not set one.
Okay. All right. So that's the default if one's not identified otherwise. Okay.
Correct.
All right. Good. That's good to know. So a well-built operating agreement needs to discuss the management structure, how the money is going to be handled, address triggering events such as death and disability of any shareholders or managing or the operating shareholders, or
all of the above. Whatever contingency they want to build in,
right.
We can do that. One that I haven't mentioned that I think is really critical is when I have clients come in, they're starting a new business, and it's especially where it's going to be a 50-50 partnership.
Right.
That is ripe for a deadlock scenario.
Yes.
One says yes and one says no, and if your agreement does not set forth how we're going to solve that deadlock, they're going to be heading to the court and litigating with each other. And so there are various ways to set out how you're going to solve that deadlock. Are you going to give a mediator or an arbitrator the right to solve that situation? Are we going to name a third party who can step in and solve that? What I am fond of is, and if they can't resolve it, what I'm really fond of is what's often referred to as a Texas shootout provision.
Say that again?
Texas Shootout.
A Texas Shootout. That sounds like an old Western. Sounds pretty good. Tell us more.
It's interesting. So let's say you and our business partners, we've reached that deadlock, and we just decide that this can't go on anymore.
All right.
So the agreement will say, I can come to you and make an offer to you in writing to purchase your shares, but when I hand you that offer, I am also saying I am okay with selling my shares to you at the same offer that I've just made to you. And the recipient of the initial offer then holds the cards on whether they are going to be bought out or whether they are going to buy out their partner.
Okay, so one party, if there's this deadlock in a 50-50 arrangement, one party can say, I will buy your interest at this number, and I'm also willing to sell my interest at this same number. So that sort of forces, if you will, the party that's making the offer to come to the table with sort of a best efforts equitable arrangement.
Absolutely.
So they have to eat their own cooking in this case.
That's correct.
So that's a Texas shootout provision. We need to wrap this up. I have a question for you. I've heard or learned or read or, you just sort of bump around. You have conversations with people over the years and you watch situations. And there's two thoughts I have. But one thing that I've heard is that a best case scenario is that there is no single person with a flat 50% ownership, just for the reasons you were discussing, that it lends itself to deadlocks and to tension and to unnecessary tension and disagreement.
Correct.
Unless someone comes to your office and they absolutely insist that they will always be friends forevermore, amen, and they would never have a disagreement, doesn't matter. Even if it's 20 degrees in August in Atlanta, they're not going to disagree, okay? But short of that kind of conviction on their part, what do you generally recommend to avoid these kinds of deadlocks? Like somebody owns 50% plus one share?
That's a common way to do it is just make somebody have that 51. With starting that new entity, and everybody's kind of hopes and dreams are building around what this future could look like in a partnership where they're wanting everything to be equal. Some of them are just not willing to have that additional. So then we end up with these provisions that help get us out.
At least you include that what you refer to as a Texas shootout provision, so that when that disagreement does come, that there's some language that facilitates resolution.
Correct.
Okay. Now I have a question. Though about minority interest, and that is, what actual authority do minority owners have? But before we get to that, let's wrap up this first episode of Stewarding Family Wealth here at Gwinnett Business RadioX, brought to you by Centurion Advisor Group. Folks, tune in just on the next episode and let's continue this conversation. That's it from here. Thank you for listening.